sent you a request for the submission of the 5-year declaration of assets and personal interests. And on the 11th of July, you submitted your 5-year declaration. The Commission also asked candidates to voluntarily complete and submit an ethics questionnaire, and you did so on the 27th of June of this year. The Commission sent you 3 rounds of questions on 30 August, 2 November and 15 November, respectively. You were asked a total number of 27 questions, including 65 subparts, and 24 of those questions included a request for further documentation. According to Article 3, Paragraph 4 of the evaluation rules of the Commission, a candidate may not provide information, documents, or other materials during the hearing if the Commission requested these earlier and the candidate did not provide them within the time specified, unless, of course, the candidate provides sufficient justification for this. Members of the Commission will now start with asking you questions. In this case, I will start with asking you questions. We will try to keep our questions short and to the point, and we ask that your answers be short and to the point as well. My first question relates to the purchase of an apartment in Chisinau. On 7th of June 2022, you bought an apartment of just over 74 square meters in Chisinau. This is an apartment against a preferential price and forms part of a program for the improvement of living conditions for judges and prosecutors. You have provided the Commission with a copy of the sale purchase contract, according to which the price for this apartment amounts to just over 31,000 euros, which is about 635,000 lei. You have also provided the Commission with a copy of the application to the Superior Council of Magistracy of 15 March 2018 for participation on the program for the improvement of living conditions. The Commission also has a copy of the minutes of the meeting of the SCM of 30 June 2021, according to which your application was approved. You explained to the Commission that you applied for the program as you intend to transfer to a higher court in Chisinau and that you do not have living space there. You also indicated that the SCM is fully aware of the fact that you own a house in Ungheni. In order to pay for the apartment, you have taken a loan from a long-term acquaintance of you. You signed a loan agreement with him on 6 June of this year for the amount of 635,000 lei. According to the agreement, you were required to pay back the loan on 1 October of this year. On 7 June 2022, you received already 536,000 lei from him, an amount that is nearly 100,000 lei lower than what was stated in the loan agreement. And on the 9th of June, so 2 days later, you transferred 564,000 lei to Bas Constructs, the company constructing the apartment. In a further round of questions, you informed the Commission that you'd already received 100,000 lei from your acquaintance about 2 to 3 months earlier in order to transfer a partial payment to the company that constructs this apartment. You explained to the Commission that you took a loan from this acquaintance as the construction of the apartment was not yet finished and not completely registered with the land registry, and that you therefore cannot take a mortgage from a bank. You also explained that as soon as the construction of the apartment will be finished, you intend to take a loan or a mortgage from a bank and will then pay back the loan to your acquaintance. In response to follow-up questions, you also informed the Commission that the registration of the apartment with the land registry was foreseen by September 2022, but that this has not taken place yet, but is expected to take place before the end of this year. You also informed the Commission that you have verbally agreed with your acquaintance that the loan from him will be extended until the end of this year. I've now a number of questions to you. The first questions are there primarily to confirm the facts as I presented, and after that we have more room for a further elaboration on the issue that we discussed with you. So my first question is that can you confirm that you have taken a loan from an acquaintance of yours amounting to 635,000 lei to pay for an apartment in Chisinau for about the same amount of money?
Yes, I confirm.
Can you also confirm that the loan will be paid back as soon as the apartment has been registered and you will be able to take a mortgage for this apartment?
Yes, I confirm.
Can you explain to the Commission what steps you have already taken towards a bank in order to get a mortgage?
So far, I didn't do anything because the apartment is not registered with Cadastre yet. So I am waiting for it to be registered finally. I would like to mention that these apartments are finished at the beginning of a year, since the beginning of a year, but there are disagreements between the construction company and the city hall regarding the land plot. That's why they cannot register the entire block of flats and apartments individually.
Can you explain to us to what extent are you certain that the moment the apartment will be registered that you are able to take a mortgage from a bank? Is there any guarantee that you can have that?
I don't know cases when a citizen wants to access a credit having a new apartment that can be set as collateral and to get a refusal. But if this happens, there are other ways out of it. For instance, my son has a new apartment in Ungheni. If he wants to move to Chisinau, he could sell it and we could give the money to the citizen and then register this new apartment on the name of my son. That would be another option, and maybe others as well. But I am confident that it cannot happen. I mean, there are many banks, and they are happy to give loans if they can get as a collateral something significant.
And please explain why this acquaintance of yours was willing to provide you such a loan.
This acquaintance, well, we have a common friend. Through this friend we met back in, a business person from Chisinau and has such resources. I could get this loan from a close relative of mine. I mean, I have some close relatives who could, but in order to avoid speculations that this is money laundering or something else, I did not do that. I could have found this amount and borrow it from someone from Ungheni. And in order to avoid suspicions that I'm working there and I'm a judge and I'm a president of a court, in order to avoid all these kind of rumors, I thought this solution was better in this case.
That actually goes into my next question. Can you explain whether this person or a family member of this person has ever been involved in proceedings as a party or a representative of a party in which you as a judge were required to take a decision?
No such situation happened. Not in cases that I manage and not even in cases that my colleagues at Ungheni Court are examining. No kind of interaction like this.
And did you take any investigations or any research and did you have any guarantees about the legality of the resources of this acquaintance?
As I said before, it's a businessman from Chisinau with a good reputation. I have never heard anything negative about this person, not from my acquaintances and not from the public space.
Can you also confirm that you submitted this request for participation in the program for improvement of living conditions for judges as you intend to transfer to a higher court in Chisinau?
Yes.
Have you undertaken any steps either prior to the moment you applied or after you applied in 2018 in relation to a career switch and to move to a court? Is there any progress in that respect?
In that period of time, I intended to run for a position of a judge in the Supreme Court. The political situation was very complicated, and because judges were ultimately appointed by a parliament's decision, I decided to wait. 3 years ago, the law on Superior Council of Magistracy was amended, and a new additional SCM member position was launched on behalf of First Level Court, and the competition was launched for that position. 3 years ago, I registered, applied for that position, SCM member on behalf of First Level Court, and 3 years until now, I'm still a candidate for that position. Then the law changed again. This position was eliminated, but in a way, competition for the new membership of the SCM started, which hasn't happened for so many years now because the General Assembly did not take place. And the fact that I am in front of you is proof that for 3 years I've been intending to move to Chisinau.
Thank you very much. That was the first round. I will now pass on to my colleague, Tatiana Raducanu, for follow-up questions.
Good morning, Mr. Șchiopu. I am going to ask you some questions about your donation that you made to your son. So let's see the facts. On March 16th, 2018, you donated to your son an amount of 5,000 euros. That would be around 100,000 lei. As you explained to the Commission, this donation was made to reserve funds for the wedding of your son, which was planned to take place in October 2018. According to your 5-year declaration to the Commission, the wedding took place in October 2019. According to Article 4, Paragraph 1, letter C of the law 133/2016, and the instruction on the way of filling out the declaration of assets, the goods provided by the subject of the declaration offered for valuable consideration of free of charge, personally or by his family members, if the value of those goods was higher than 10 average monthly salaries in the economy. The average monthly salary in 2018 was 6,150 lei, which means any donation higher than 61,500 lei was supposed to be declared in your declaration of assets and interests for 2018. However, you failed to do so. Subsequently, in your asset declaration for 2021, you declared a loan of 122,000 lei, which you obtained from Moldinkom Bank for the years 2021-2023. You informed the Commission that this loan was contracted in order to pay partially the price of the apartment that your son purchased, Gheorghe Șchiopu. Your son indicated this amount as a donation from you to him in his asset declaration for 2021. So again, according to Article 4, Paragraph 1 of Law 133, a donation exceeding 10 average monthly salaries per economy shall be declared. The average monthly salary for 2021 was 8,716 lei, which means any donation higher than 87,160 lei should have been declared in your declaration of assets and interests for the year 2021. However, you failed to do so. When asked by the Commission for a clarification, you said it was a mistake. So please answer the following questions. Please confirm you donated 5,000 euros in 2018 to your son. I will answer your question. I did not donate 5,000 euros to my son. This money was reserved for wedding expenses. This money was given to him to keep them. He put the money into the account so that before the wedding, they could be withdrawn from the account and spent by me, first of all, for the wedding of my son. Do you mean there was no donation contract? Or you just give it no donation in itself and no donation agreement? They were given to him for storage because for hundreds of years, Moldovans organized weddings of their children, and wedding expenses are never recognized as a donation. Donation is what you give at the wedding, a car, a house, money that you give as a gift. But what the parents spend for the wedding celebration is wedding expenses. It's our tradition for hundreds of years. But how did you transfer? Did you just give cash and he put it in the bank? Yes, I gave him cash and he put it in the bank. I did not even know which bank. I found out from the commission that it was OTP Bank. Please confirm you did not declare this in your asset declaration for 2018. No, I did not. Because I did not consider them as a donation, as I said. Please confirm you had the obligation to declare this donation. Do you think you had the obligation? If it was not a donation, I did not have an obligation. So you don't call it donation. How do you call it? Wedding expenses. And that all Moldovans for hundreds of years are making, and they are never nowhere treated as a donation. Please confirm you donated 122,000 lei to your son in 2021. Yes, I confirm I donated this amount. Is it through a donation contract or how was it? I obtained a loan and immediately at the bank I made a transfer order to Șchiopu Gheorghe. I wired to the construction company for the apartment of my son, Șchiopu Gheorghe. Please confirm you did not declare this in your declaration for 2021. I confirm I did not declare because I just missed that. My son, who is also a civil servant, I told him, don't forget to declare this. I declared in my asset declaration that I got a loan from the bank. And in that payment order, it was written what it was, but from some technical lack of attention, because usually under donations, I was usually writing if I received something. But also, given that this declaration is adopted automatically, there are some changes from a year to another. And in this respect, I just, by mistake, I missed to write that, I admit. Please confirm that you had the obligation to declare this. Do you think you had the obligation to declare this? Now I think so, yes? It wasn't a problem, meaning that everything is transparent and declared. It's just I did not write this in the appropriate cell field. So you think it's a mistake of yours, lack of attention. How do you treat this action? I think it is a mistake, an omission. At that point, I did not think it had to be declared because I said, I told my child to write that, to declare that. I declared the loan contract and for what purpose. In the transfer order, it was written that it was for that apartment on the name of Șchiopu. And for the lack of attention, I did not write it in this field. Okay, we have two cases in your case, 2018 and 2021. In 2018, you said it wasn't a donation, it was a transfer of money, yes, for storage, so that he would be confident that he has money for the wedding. According to the law, you had to declare no, because it was not a donation. But we are talking about goods. The law says that the goods that are transferred by the declarant, and when you say goods, everything falls under there, including money. Yes, this is money if it's for a certain purpose, but if it's for storage, it's not. I did not give the money for my son to use them. The money I gave to my son was supposed to be used by me, but later. In the end, I was the one who paid that money to the wedding restaurant place. So you took this money from, well, my son took the money from the account, gave it to me just before the wedding, and I personally made the payment to the restaurant. Well, it was in a way a guarantee that he has money for the wedding, because many things could happen. I could have gotten sick or died, but he had the guarantee that he had money for the wedding. That's a parental obligation. Would you like to add or clarify anything else about this? No. Any questions? Okay, let's move on. Another matter is about the declared value of a car. Let's see the facts. In the name of your son, there is registered a car, Honda, make year 2012. You said that you informed the commission that the car actually belongs and was purchased with your money. Your son purchased this car in 2016 in Germany when he was working there. For practical purposes, it was easier for the car to be purchased and registered in his name rather than in your name. According to the information from the customs service, the value of the customs value of the car on 7th of January 2017 was 270,000 lei and customs fees of 71,000 lei. So the total value of the car as of the beginning of 2017 was 341,000 lei. In your answers to the commission, you declared you were unable to provide the sale purchase contract related to the car. You, at that time, provided it to the Public Services Agency, transport registration of Ungheni, where, as it was provided more than 5 years ago, that contract was disposed of and you did not have a copy. You also declared that the car was purchased in Germany at the price of 12,000 euros. That would be 235,000 lei, excluding the value-added tax that the seller collected after the car was taken out of the country. Please confirm that your son imported from Germany the car, Honda, year make 2012, in early 2017. I confirm. Please confirm that the purchase price of the car in Germany was 12,000 euros. Yes. Please confirm that the customs service declared that the total value of the car was 341,000 lei. That included the customs value of 270,000 and custom duties of 71,000 lei. I don't know. I don't know because I did not handle this car business at all. Please confirm that you declared the value of the car in the 2017 to 2021 declarations as being 180,000 lei. I declared it because this was around 12,000 euros. Why 180,000? I mean, how 12,000 euros is 180,000? I think that was the equivalent at that time in 20-something. So you took the equivalent. How did you calculate? How did you get to 180,000 lei that you declared? It was the equivalent of 12,000 euros. At the exchange rate on the date of declaration? When was that? 2017 to 2021. It's several declarations. I don't remember. That's for 4 years you declared it was the same amount. The initial price was declared, even though the car depreciates as time goes by, even if it stays in the garage, only by time passing by, the price of the car goes down. But I was mentioning the initial price without any changes. And as I said, when filling out the declaration of assets and interest, on the page, you can see the previous year's declaration, and you only make the necessary changes. And in terms of house and cars, there were no changes. That's why I did not even look into that, and I did not calculate anything. And I think in the last year, I declared a small amount because the value of this car depreciated a lot because there are a lot of years passed. But 180,000 lei, you calculated in 2017 according to the euro exchange rate in 2017. I think so. I don't remember. Okay. Please explain why this amount. How did you come? This is important. How did you get to this amount? From what I remember, it was the price, the 12,000 lei, equivalent to Moldovan lei, at the exchange rate of 2017 or even 2016, because the car was brought in 2016 but purchased in 2017. Okay, would you like to add anything or clarify further with respect to this car? No, know. If you have any more questions, I could answer. Good, thank you.
I will now get back to the last set of issues with you, and it relates to the declaration of a number of bank accounts. So the facts as we would like to present to you are the following. In the period 2012 to 2015, you did not disclose 5 bank accounts in your name or in the name of your wife. We've provided you with a copy of the list of the bank account numbers, but of course we will not make reference to those numbers during the hearing. In 2012, a bank account was opened on 13 February in the name of your wife, and in 2013, 3 bank accounts were opened on 7 May 2013 in your name. It is one number, but it relates to a bank account in lei, in euros, and in US dollars. And then another one in 2014, an additional bank account was opened on 12 June, also in the name of your wife. As of the moment of opening of these bank accounts until the end of 2015, none of these bank accounts were declared. When we asked about those bank accounts, you answered the Commission that you declared that those accounts represent the bank accounts on which you and your wife receive salaries and pension, and that you did not declare them as none of them exceeded 15 average salaries per economy, except for one of them which relates to a loan. Can you confirm that you and your wife had these bank accounts in the periods 2012, 13 and 14?
Well, speaking in classical terms in terms of what a bank account is, these are not bank accounts. They are a technical instrument or means to receive salary. So the accounts are actually cards whereby we used to receive salaries and the pension for 10 years because I was a prosecutor. And thus, before filling in the declarations on assets and interests, there was usually no more than one loan on those accounts. You would always use to withdraw the money. Either way, it was never above the amount of a salary or 2 on those accounts. There was never more than that. Initially, we used to declare these accounts in the declarations on assets that used to be submitted with the SCM. But then we agreed that if these are salaries that we declare under salaries, then why should we repeat that? And the absolute majority of colleagues stopped declaring the accounts that they received salaries on, especially if there was nothing on those accounts at the time that the declarations were being filled in. Now, with regards to the accounts in foreign currency, my daughter has studied for a year in high school from the U.S., and there was a project funded by the U.S. government, the FLEX project that is, and all the expenses were covered by that project. The U.S. government was covering all expenses. However, as she lived there for a year, there were different needs that needed to be catered for. And several times I transferred a few $100s. And the greatest transfer was worth $500. There were 2 or 3 transfers. So that's why it was necessary to have one. On that account, I never kept any $1 even. We only opened it specifically to be able to transfer money to the U.S. And it was used like a technical vehicle for transfer. But in terms of depositing money there, keeping it there, and receiving money there, that was not the case. Then, after graduating from high school, my daughter was enrolled in the Cluj University. And sometimes we'd transfer 100 or a couple of hundreds euros to the daughter because although, well, the education fee would all be covered by the Romanian government. She had a student stipend. Anyway, she still had some other expenses that we helped with. And throughout the year, we would transfer about 300 euros. And that was the purpose of that account, specifically to transfer the funds that I mentioned to my daughter, because that was just used as a tool for transfer. I never kept deposited money on that account. I did not receive money through that account, and thus I did not declare it. Now, with regards to the account in lei, it's the same. It was meant for the daughter. Sometimes we would transfer it in lei, and she would convert it into the local currency when she received it. So I did not have money, I did not receive money, I did not deposit money on those accounts.
I'd like to refer to law number 1264/2002, which was in force until the 1st of August 2016. And according to Article 4, paragraph 1, literal D of that law, the subjects of declarations have to declare all financial assets, so including bank accounts, investment funds, etc., regardless of their value. It was only after the entry into force of law number 133 of 2016 that only such bank accounts would have to be declared if the value exceeds 15 monthly average salaries. So basically, until 2016, do you confirm that there was an obligation to declare all those bank accounts regardless of the value on it?
So, as I said, those accounts were rather a vehicle, a means to receive salary. As for the declarations on assets, they are submitted to the SCM, and then they would further pass them on to the current National Integrity Authority. All the stakeholders knew that we received the salaries on the cards, and we wouldn't declare that. Nobody ever claimed anything about it. Nobody ever demanded anything. Since when we stopped indicating that, declaring that, nobody asked us to actually stipulate it. So formally, it feels like that was a violation.
To add on in relation to this question?
No, mulțumesc.
Okay.
No, thank you.
At, my colleagues, is there anyone else who has any follow-up questions? If that is not the case, then I would like to give you the floor now to, if you would prefer to make a brief closing comment to us. Please go ahead.
I would like to thank you for having listened to me and for being there with me in this period, which is not the very maybe nicest of the experiences in terms of having to answer questions, because we're also in that position where we ask other people questions and they also might not be very comfortable answering them. On the other hand, I would like to also congratulate everyone in this room on the occasion of the 1st of December, which is the National Day of Romania. That was all. Thank you.
I was not aware of that, so I'm learning every day. But thank you so much. We now come to the end of the hearing, and I thank you, of course, for answering the questions that we had to you this morning. The Commission will now withdraw for deliberations, and as much as possible, the Commission will strive at delivering a decision within a month after the date of this hearing. I thank you again very much, and I hereby declare this hearing closed. Thank you.